Hi, I'm attorney James Betzold. I'm an immigration attorney, and I'm here to share with you 5 things that you need to know about filing an I-601 waiver for inadmissibility. Now, the waiver of inadmissibility is usually done on Form I-601. There's also a Form I-601A, which can be filed in the U.S., and it only covers unlawful presence. It doesn't cover some of the others like fraud or misrepresentation or other things that exist. But in talking about these I-601, I-601A waivers, here's some things that you need to know. First of all, your chances of success increase a lot when you have an attorney. Now, do attorneys have special powers or get special preference or anything like that? No. But the other thing is we have done this a lot, and it's what we do every day, and it's our specialty, so we're good at getting it right the first time. For people who file their petitions without an attorney, about 40% of those get approved and about 60% get denied. That number goes way up. It's in the high 90s when you use an attorney with experience in the field. So that's thing number 1. Your chances of success go up with an attorney. Thing number 2, when filing one of these waivers, you need to show hardship, but not to yourself. The government doesn't care if, under this waiver, right, the government doesn't care if you're going to suffer any particular hardship. They care if your family member who's a U.S. citizen or legal permanent resident is going to suffer hardship. If one of those special people is going to suffer, well, then you can maybe qualify so you can come into the U.S. and then they won't suffer. That's the idea. Now, remember, it's a U.S. citizen spouse or parent you need to have as a qualifying relative. Those are the only ones who you can show hardship to that's going to qualify you for a waiver. So if you say, well, I've got kids and I'm a good person, doesn't matter. Your kids are not your spouse. Your kids are not your parent. So you need a spouse or a parent who's a U.S. citizen or a legal permanent resident to qualify for this waiver to begin with. Thing number 3, your hardship has to be very well documented. Now, the government loves to send out what are called requests for evidence, and they do it in most of these cases these days. And they'll say things like, well, we know that your U.S. citizen spouse is going to have a hard time if they can't work overseas, or if they can't have you there to be with them, because then they'd have to pay for childcare. But that in itself is not extreme and unusual hardship. And that's the normal type of hardship to be expected. Or they may say something like, yes, well, we know that your spouse is going to be sad, but mere sadness does not rise to the level of extreme hardship that one must show to have this waiver approved. And they say it just like that too, okay? So the hardship you have in every area of your life needs to be well documented with proof that the government is going to be willing to look at and approve. I also suggest a detailed brief explaining the situation to spell it out for them. Thing number 4, when filing this waiver, you got to actually explain the evidence in 2 scenarios. You need to explain how your spouse is going to suffer if you're separated for 10 years and you live in the foreign country and your spouse is living here. But you also need to explain how your spouse is going to suffer if they have to come overseas and live with you for 10 years. Now, think of the logic behind this. The logic behind this is that, well, if you can't come here, then your spouse is going to go there, and obviously your country is going to let your spouse in. Obviously they're going to let you do that, even though that's not the case in our country. You have to get all this paperwork and waiver filed. So there's some nonsense to deal with, logically speaking, but you need to document in those 2 scenarios that there's going to be an extreme level of hardship. And that brings us to our last point. Point number 5, you can try again. Let's say the worst thing happens. You file this waiver on your own. It gets denied. What do you do? Is that the end of the game? No. Find an attorney and try again. You can file this waiver as many times as you want to pay the filing fee for it to be approved. Just be sure to send more evidence the next time. Just be sure to document things better. Be sure to bring anything conceivable or possible that they ask for or later ask for in a request for evidence. The I-601 or the 601A waiver is an excellent tool that we use every day to help unite families and bring spouses back into the United States so that they can live here and prosper and be together with their family and have like a basic sort of decent life. So if this is something you're considering or you might need help with, I'm attorney James Betzold. You can find more information at betzoldlaw.com. That's BETZOLDLAW.com. We offer online appointments, video conference appointments, telephone appointments, or in-office appointments as well. Thanks. Have a great day.